Despite all its procedural protections, California's criminal justice system has produced a documented record of wrongful convictions, and confronting that record is essential to understanding the system honestly. According to the National Registry of Exonerations, California has had more documented exonerations than any other state in absolute terms, a reflection of both its large population and its relatively robust infrastructure for post-conviction review. The leading causes mirror national patterns: mistaken eyewitness identification, which is the single largest contributor, false confessions, especially from vulnerable defendants like juveniles or those with intellectual disabilities, unreliable forensic evidence, perjury, and official misconduct by police or prosecutors. A central player in correcting these errors is the California Innocence Project, founded in 1999 at a San Diego law school. It reviews more than 2,000 innocence claims a year, investigates the strongest, and pursues post-conviction relief. It has secured the exoneration of more than 30 people, representing thousands of years of wrongful imprisonment, while also pushing systemic reforms to eyewitness procedures, interrogation recording, and DNA testing access. But there's a deeper structural factor at work. Each of California's 58 counties effectively runs its own criminal justice system, with locally elected district attorneys, locally funded public defenders whose resources vary enormously, and county jury pools. The result is that where you're prosecuted can be as determinative of your fate as what you're accused of doing. This brings us to the most active reform period since the tough-on-crime era, from 2011 to 2021, driven by court-ordered population reductions, fiscal pressure, and shifting public attitudes. California enacted a substantial body of reforms. Many took effect in January 2021: misdemeanor diversion, automatic expungement of eligible records, bans on chokeholds by police, restoration of voting rights to people on parole, caps on probation length, and the California Racial Justice Act, which lets defendants challenge racial bias in their charging, conviction, or sentencing. Together, these mark a genuine philosophical shift from a system centered on punishment toward one that weighs rehabilitation, proportionality, and racial equity. But the trajectory hasn't been linear. The very same 2020 ballot also passed Proposition 20, which reversed parts of earlier reforms, reclassifying some misdemeanors back to felonies. That tells you the electorate's views are genuinely conflicted. And persistent racial disparities, despite all the formal reforms, reveal the core challenge. Changing the law on paper is necessary, but not sufficient to change practice on the ground across 58 separately administered county systems.